The Supreme Court delivered a major ruling this month that has gun owners across the country on high alert. 8 particular firearms currently in civilian hands are either prohibited already or facing imminent bans in numerous jurisdictions. The mainstream coverage isn't explaining how this truly impacts everyday Americans, which is precisely why this broadcast exists. This isn't hypothetical. This isn't years down the road. This is unfolding right now in March of 2026. If any of these 8 weapons are in your collection, every moment of this program is essential listening. Before I enumerate each firearm individually, I have a question for you. If safeguarding your constitutional freedoms matters to you, tap that subscribe button immediately. Here's the situation at the nation's highest court and why it carries direct consequences for your household. On March 2nd, 2026, justices heard oral arguments in a significant firearms matter titled United States versus Rahimi. The central issue involves federal authority to prohibit weapon possession by individuals who consume cannabis, including in jurisdictions where such use is lawful. The bench appeared doubtful of the government's stance, suggesting potential relaxation of this prohibition. However, there's a complication. That very same afternoon, the court declined to intervene in another weapons restriction. The Supreme Court permitted a Maryland decision to remain intact, authorizing the state to confiscate firearms from individuals receiving sentences exceeding 24 months incarceration. 2 substantial firearms developments, identical date, entirely contradictory trajectories. This illustrates precisely the current state of weapons rights jurisprudence. The judiciary is simultaneously extending protections in certain domains while contracting them elsewhere. Meanwhile, beneath this high-profile conflict, state-level prohibitions continue accumulating. Some restrictions are long-standing, others recently activated. Additional measures will take effect within mere months. The firearms appearing on this roster represent those currently ensnared in this legal turbulence. Permit me to provide brief historical context before presenting the inventory, as this foundation illuminates everything following. During 2022, the Supreme Court issued a historic opinion in New York State Rifle and Pistol Association versus Bruin. This 6-3 holding established that firearms regulations must demonstrate alignment with American historical customs. Stated differently, absent foundational era origins, legislation likely cannot survive constitutional scrutiny. That determination was anticipated to complicate state efforts at restricting weapons, and indeed has in certain regions. Conversely, other jurisdictions interpreted the ruling as provocation and intensified their regulatory efforts substantially. Hold momentarily. Should jurisdictions advancing these prohibitions face judicial intervention? Share your perspective in the comments. While there, activate that appreciation indicator. This assists our platform's continued advocacy for your liberties. This introduces the 8 firearms presently unlawful, limited, or confronting substantial jeopardy across multiple states. These aren't theoretical scenarios. These aren't forecasts. These represent weapons that actual collectors are being informed they cannot purchase, convey, or under certain circumstances, retain. Let's examine them sequentially, commencing with the most recognizable and concluding with one that will genuinely astonish you. The initial firearm is the AR-15 platform and its derivatives. This constitutes America's most prevalent long gun, presently prohibited from retail, production, and transfer in no fewer than 10 states, specifically California, Illinois, New York, New Jersey, Maryland, Connecticut, Hawaii, Massachusetts, Delaware, and Rhode Island, the latter having recently enacted its prohibition effective July 1st, 2026. Residing in any of these jurisdictions and attempting AR-15 acquisition today results in denial. Current ownership carries additional complications. Several of these states mandate registration or eventual relinquishment. The AR-15 isn't targeted merely due to intimidating aesthetics. It's targeted because it represents America's most ubiquitous contemporary rifle. Prohibiting it transmits the most forceful conceivable statement. The second category encompasses AK pattern rifles. Consider semi-automatic variants of the AK-47 or AK-74. These face prohibition across the identical state, grouping restricting AR-15s. California's statute bans them by specific designation. New Jersey maintains an enumerated catalog of forbidden models incorporating AK configuration rifles. New York's secure Secure Ammunition and Firearms Enforcement Act encompasses them through characteristic evaluation. Here's where complexity emerges. The characteristic evaluation stipulates that semi-automatic rifles possessing detachable ammunition feeding devices, plus even singular specified attributes, collapsible stocks, ergonomic grips, or thumbhole configurations, qualify as assault weapons and face prohibition. The weapon needn't appear on any designation roster. Merely satisfying that singular attribute threshold triggers prohibition. The third category involves semi-automatic handguns with regulated characteristics. Most individuals remain unaware this classification even faces targeting. New Jersey explicitly prohibits semi-automatic pistols exceeding 50 ounces unloaded weight. New York and California similarly maintain attribute-based regulations, potentially transforming conventional semi-automatic handguns into prohibited weapons given particular accessories or stock arrangements. Therefore, residents of these states who've implemented certain modifications to their handguns may have inadvertently crossed regulatory boundaries without awareness. The fourth category is the 50 caliber long gun. Illinois, through the Protect Illinois Communities Act, colloquially termed PICA, specifically prohibits 50 caliber rifles and corresponding ammunition. California additionally restricts 50 BMG rifles. These represent extended distance, when high-velocity precision instruments. They're costly, specialized, and infrequently encountered at typical shooting facilities, yet they appear on prohibition rosters. Ownership in these states creates substantial legal vulnerability. The significance isn't widespread 50 caliber rifle ownership. The significance is governmental boundary establishment and subsequent redefinition of protected categories. Here's an aspect of this situation that even dedicated firearms rights outlets are overlooking. Momentarily, I'll address two inventory items receiving minimal public attention. First, enable our alerts. Activate them immediately, because when tribunals issue fresh determinations regarding these prohibitions, immediate notification becomes essential. The fifth inventory item is semi-automatic scatterguns with specified attributes. Multiple states prohibit semi-automatic shotguns combining detachable ammunition feeding with characteristics including collapsible stocks, ergonomic grips, or thumbhole configurations. This implies tactical semi-auto scatterguns marketed for residential protection might now fall under prohibition in your jurisdiction. Delaware's assault weapons statute explicitly encompasses these. New York addresses them through the SAFE Act's characteristic evaluation. California has restricted particular configurations for extended periods. The difficulty: these scatterguns retail legally in unrestricted states, frequently promoted as defensive instruments, yet entering restrictive jurisdictions with improper characteristics creates legal exposure. The sixth item is the AR handgun with stabilization brace. This carries multiple dimensions. The Bureau of Alcohol, Tobacco, Firearms, and Explosives under the prior administration promulgated regulation reclassifying stabilization braces as shoulder stocks, which would have effectively reclassified millions of AR handguns as short-barreled rifles instantaneously. That regulation became entangled in litigation. Here's the current state-level reality. California, New York, New Jersey, and additional jurisdictions either previously encompassed these within assault weapons definitions or implemented measures addressing what they termed the brace loophole. AR handguns in prohibited states generally remain prohibited weapons regardless of brace presence, because the underlying firearm still triggers characteristic evaluation or designated model prohibition. The seventh item is the large capacity ammunition feeding device itself. Indeed, the magazine matters because it potentially renders the firearm unlawful. Follow this carefully because significance exists here. California prohibits magazines containing more than 10 cartridges. Illinois prohibits magazines containing more than 10 cartridges. New York prohibits magazines containing more than 10 cartridges. Colorado prohibits magazines containing more than 15 cartridges. When your weapon ships standard with magazines surpassing these thresholds, and you reside in these states, your firearm undergoes categorical reclassification, and mere possession constitutes violation. Consider the magazine as the mechanism converting lawful weapons into unlawful ones. This represents how regulations ensnare otherwise compliant collectors daily. The eighth item, and this will genuinely surprise you, is the revolving scattergun, specifically in Rhode Island. Rhode Island's recent statute, enacted and effective July 1st, 2026, doesn't merely prohibit semi-automatic rifles. It explicitly designates revolving shotguns as forbidden firearms. This is atypical. This represents a weapon category most individuals never considered politically targeted, yet there it appears inscribed directly in fresh legislation. The revolving scattergun prohibition in Rhode Island signals approaching development. These emerging statutes don't merely target weapons appearing in media coverage. They're expanding definitions, broadening scope, and ensnaring firearms collectors never anticipated facing targeting. Now, let's examine what this signifies for your future, because the legal terrain continues evolving. The Bruin determination from 2022 was anticipated to transform everything, and indeed functions in certain tribunals. A federal tribunal recently invalidated the District of Columbia's magazine prohibition days ago in March 2026, determining that commonly possessed magazines receive Second Amendment protection. This constitutes genuine victory, yet here's what most observers miss. Prevailing in tribunal doesn't automatically transform your state's law immediately. Additional litigation, appeals, and years are required. Meanwhile, prohibitions remain active. Law enforcement continues enforcement. Arrest remains possible. Illinois' assault weapons prohibition under PICA currently faces challenge in the 7th Circuit Court of Appeals, with connections to matters awaiting Supreme Court review. Firearms rights organizations have petitioned the Supreme Court to intervene and nullify the Illinois statute. Thus far, the court has permitted lower tribunal processes to continue. Should the Supreme Court eventually directly address an assault weapons prohibition matter, it could transform the entire national landscape simultaneously. This would constitute the most significant Second Amendment determination since Bruin. However, that determination hasn't arrived. Until it does, those 10 states may maintain enforcement. An enormous conflict is additionally developing regarding the meaning of commonly possessed. The Bruin evaluation states, government cannot prohibit weapons in widespread lawful civilian use. The AR-15 represents America's best-selling rifle, with estimated 20 million or more in civilian possession. Firearms rights advocates argue this establishes it as the nation's most commonly possessed rifle, warranting constitutional protection under Bruin standards. Firearms restriction advocates argue quantity is irrelevant. If the weapon possesses exceptional dangerousness, prohibition remains permissible. This dispute will propel litigation for coming years, with outcomes determining whether these prohibitions persist or collapse. Now let's personalize this, because here's where genuine life impact occurs. Allow me to present 3 realistic situations actual collectors currently confront. Imagine relocating from Texas to New Jersey for employment opportunity. You transported your AR-15 because you've owned it lawfully for years. You maintained it secured. You've only discharged it at paper targets. The instant you entered New Jersey with that rifle, you became a felon under state law. Unaware? The moving company didn't mention it. Your property representative didn't note it. Now you're harboring legal jeopardy in your own residence. This situation affects actual individuals presently. The prudent approach always involves researching destination, jurisdiction, firearms regulations before relocation, not afterward. Here's the second situation. You reside in Illinois and possess an AR-15 acquired before the Protect Illinois Communities Act took effect. You're grandfathered, correct? Not precisely. The statute mandates registration and regulations regarding what you may do with that registered weapon, and what occurs upon sale or transfer are complex. If you relocate out of state, then return, you may forfeit grandfathered status. If you permit family members to handle the weapon without proper procedures, you may have committed unlawful transfer. The grandfather provision sounds protective, yet contains hazards capable of still creating trouble. The third situation is one unrestricted state collectors rarely consider. You're traveling, weapon secured in trunk container, unloaded, following federal transportation guidelines. You traverse Maryland, traveling from Virginia toward Pennsylvania. Maryland maintains an assault weapons prohibition. Federal law under the Firearm Owners Protection Act of 1986 provides protection when transporting weapons through states where they'd otherwise be unlawful, provided you're traveling directly from lawful location to lawful location. However, directly is crucial. If you stop, if you overnight in Maryland, if you detour, you may forfeit federal protection, and state law enforcement in certain jurisdictions haven't hesitated making arrests. Now let's dispel 3 misconceptions spreading rapidly online because misunderstanding could genuinely cost your liberty. The first misconception is that Bruin already rendered all these prohibitions unconstitutional. It didn't. Bruin established fresh standards, yet didn't automatically nullify every existing state statute. Each prohibition requires individual tribunal challenge. It must survive appeals. It may eventually reach the Supreme Court before actual nullification. Bruin represents framework, not instant solution. Consider it analogous to fresh officiating personnel arriving with revised rulebooks. Previous infractions continue being called until officials approach that specific play and whistle. Officials haven't approached every play yet. Prohibitions remain effective. The second misconception is that weapon availability at retail establishments indicates legality in your state. This is dangerously incorrect. Some dealers err. Some operate near jurisdictional boundaries, primarily serving out-of-state clientele. Some retail weapons lawful in their state, but not yours. The establishment selling to you doesn't constitute legal protection. You bear responsibility for knowing your state's regulations. But the dealer sold it to me fails as courtroom defense. Never assume legality from availability. The third misconception is that these statutes only target criminal elements, so law-abiding individuals face no concern. This is precisely inverted. These statutes specifically target collectors with zero criminal history. They take weapons you purchased lawfully, registered, and stored responsibly, then reclassify them as unlawful through legislative action. That's the entire objective. Law-abiding collectors suffer most from these prohibitions because criminal elements disregard registration requirements or characteristic evaluations. Those most jeopardized by these statutes are individuals like yourself. Remember this, because truth matters here. Let's conclude, because you've remained through substantial information and you merit clear summary of essential takeaways. 3 elements require retention before departing this broadcast. First, the 8 weapons addressed today: the AR-15 platform and derivatives, AK pattern rifles, regulated semi-automatic handguns, 50 caliber long guns, characteristic restricted semi-automatic scatter guns, AR handguns in prohibited states, weapons paired with large capacity feeding devices, and Rhode Island's revolving scatter guns. These face either active prohibition or emerging restrictions right now in March 2026. This isn't future speculation. This represents present law in specific jurisdictions today. Second, tribunals are resisting, but resistance is gradual and inconsistent. The District of Columbia magazine prohibition was recently nullified. Illinois' prohibition faces active challenge. The Supreme Court is addressing multiple firearms matters this term and next. Legal momentum may be shifting, yet hasn't shifted fully. You cannot wager your liberty on unmaterialized tribunal outcomes. You must know your state's present law, because that's your current governing reality. Third, and most critically, your legal ignorance provides zero protection. It never has. It never will. If you possess any weapons discussed today, you must know precisely your state's position regarding them. You must know transportation, transfer, registration, and storage regulations. This isn't excessive caution. This mirrors the responsibility assumed when operating motor vehicles. You learn traffic regulations where you drive. You learn firearms regulations where you reside and travel, updating that knowledge whenever regulations change, because presently they're changing rapidly. Here's the ultimate conclusion. The Second Amendment was drafted for permanence. It was drafted to protect your weapon possession rights against precisely the governmental overreach we're observing in these jurisdictions presently. However, rights don't self-execute. They require informed citizens who comprehend them, advocate for them, and refuse surrendering them through ignorance or indifference. That's why you're present. That's why this platform exists, and that's why every broadcast we produce matters for you, your household, and succeeding generations. The liberty struggle never concludes. It merely advances to subsequent tribunals, subsequent legislatures, and subsequent elections. This represents merely the commencement. Subscribe to prepare when the next major determination arrives. Comment indicating which of these 8 weapons surprised you most, or which jurisdiction you anticipate passing fresh prohibition next. I review every comment. Let's discuss this.